Good afternoon, everyone, and thank you for joining us live for Legal Services of Eastern Missouri's presentation on special education and COVID-19. We are co-hosting this presentation with the St. Louis MHB and the Missouri Foundation for Health. My name is Hopi Fink, and I am an education advocate with the Education Justice Program at Legal Services of Eastern Missouri. I'm joined by Maggie Lamore, the Program Director of the Children's Legal Alliance, who will be the lead presenter today. Michelle Weltman, attorney with the Children's Legal Alliance, and Dan Underwood, the Managing Attorney with the Children's Legal Alliance, are also behind the scenes helping with responding to your comments and questions. Note that our presenters cannot see your questions here in the chat, but if we have enough time, we will be answering questions at the end of the presentation. A recording of this video will be available on our Facebook page after the live stream ends. Additionally, the slides from today's presentation will be available on the Legal Services of Eastern Missouri website. Please note also that unfortunately we are unable to give specific legal advice in response to questions and comments in the chat today, but feel free to call our intake line at 314-534-4200 or 1-800-444-0514 to see if you are eligible for legal representation from Legal Services of Eastern Missouri. Now I will turn the presentation over to Maggie Lamore.
Thank you, Hopi. Again, my name is Maggie Lamore. I'm the Program Director with the Children's Legal Alliance at Legal Services, and welcome to Special Education Advocacy. So our agenda today, I'll be doing a very brief overview of legal services and the educational legal representation we provide. I'll be talking about special education and then some advocacy tips for parents when the parent disagrees with the district. I'll touch a little bit on special education and COVID-19 and the legal landscape during virtual education. I'll talk briefly about Section 504 plans, and then if there's time at the end of the presentation, I will answer some questions. So if there are questions during the presentation, please feel free to drop them in the chat, and either Dan or Michelle may be able to answer those questions in the chat, or I may be able to answer those live at the end of the presentation. So Legal Services is a nonprofit which provides civil legal assistance to folks in the St. Louis area and Eastern Missouri in a variety of different legal areas, including education. You may contact us by phone or on our website to request assistance through Legal Services, and the information is here on the screen. So to talk about our specific programs briefly, the Children's Legal Alliance provides direct individual representation to families with educational needs. So we serve children from ages 3 to 18 who are in public schools, who are having educational issues. And then the Education Justice Program, or EJP, works with our program to address educational issues on a systemic level, looking at the causes of education inequity through a racial justice lens and a community lawyering model. The types of cases we're able to help with, if someone watching this does need some legal assistance, we help with all aspects of special education, from obtaining an IEP to making sure that the services are appropriate and are being provided. We work with families to obtain Section 504 plans. We help families with suspension and expulsion cases, and we also work with families who are experiencing homelessness, who are having trouble accessing the school program. So now we're going to talk about the IEP process briefly from start to finish. This is not a detailed presentation because to be detailed about the IEP process could take an hour. So this is going to be a brief overview. So the main special education law, when you talk about special education, or when school folks use the term IDEA, they're talking about the Individuals with Disabilities Education Act, which covers children with qualifying disabilities from birth to age 21, and it entitles them to a free appropriate public education, or FAPE. So a FAPE basically entitles a child to special education and related services provided at no cost to the parent. That's very important. Designed to meet the unique needs of each child. So every child's special education services are going to be different and should be tailored to that child's needs. And the IEP should be designed to allow the child to make progress in school. So if a child is not making progress, the district may not be fulfilling its obligation to the child. So first, what is an IEP? We use the term IEP. Schools throw around the term IEP all the time. So students who qualify as a student with a disability under the IDEA are given a written IEP, or Individualized Education Plan, and it's actually a physical document which lays out the services and accommodations that the school will be providing to the child to make sure that the child is able to make progress in school. And the information on the IEP, the services, are determined by an IEP team, which must include the parent, teachers, administrators, and any therapists or other service providers that work with the child. So who qualifies for an IEP? So it's a two-step process. First, after testing, and it can be either outside testing that the district considers or testing done by the district, the student must meet criteria for a disability that's specifically laid out in the IDEA. And since there's 12 of them, I'm not going to talk about this specifically here. I have a link in the presentation if parents are interested in finding out what are the 12 different categories. And so you must qualify in one of those specific categories. And so what that means is that not all children who need help in school are going to qualify in one of those areas. And so not every child who needs help in school is going to qualify for an IEP, because you do have to meet some of those narrow definitions. And then once a child qualifies for under one of the disability categories, the disability must have a negative educational impact. So it must be, keeping the student from making progress in some way. And we'll talk about some of the signs of that on the next slide. And to note that a medical diagnosis does not guarantee an IEP. For example, a medical diagnosis of autism is actually different from an educational identification of autism. So just because one has a medical diagnosis from a doctor, it doesn't automatically mean that you're going to qualify for an IEP, but there is at least one category which does require a medical diagnosis, which is other health impairment. So how do I as a parent know if my child needs an IEP? So really looking at, does the child need additional services beyond what the classroom teacher is capable of providing? And so signs to look for there are, is your child falling significantly behind peers in reading and math? Is that your child having difficulty paying attention in class or, doing classwork? Does the teacher have to sit next to your child in order for your child to complete work? Are you failing, progress reports, report cards? Is your child in danger of being retained because of school performance? Also missing class due to behaviors. Is the child leaving the classroom? Is the teacher putting the child out of the classroom? Is the child getting a lot of in-school or out-of-school suspensions where they're missing a lot of class and that's impacting their grades? And also significant emotional outbursts in class. If a child, reacts by either withdrawing and not doing any work or having an outburst where they're a danger to themselves or others in class, that may, point to a sign where a child may need to be tested for an IEP. And certain medical diagnoses may also indicate the need for it. And so usually a doctor should mention to a parent that they should be looking for IEP testing at school. So to request an IEP, a parent should not have to request it. School districts do have a child find obligation to find and evaluate all children with suspected disabilities. However, that doesn't always happen. And so a parent can and should make a verbal or written request. It doesn't have to be in writing. It should be in writing, for the school to evaluate the child for an IEP. And so we recommend writing a letter talking about, here are my concerns for my child, and attaching, if there's a letter from the doctor with a medical diagnosis, or any medical records that are helpful, it's helpful to provide those as well. But a medical diagnosis is not required to request an IEP, because most of the disability categories do not require a medical diagnosis. So the specific evaluation process, once that IEP has been requested, the school district has 30 calendar days to respond to that request. And there are only two ways to respond to that request, either by scheduling a review of existing data meeting to look at the child's current school performance and all the information that they have on the child to determine if additional testing needs to be done. For example, IQ testing, academic testing, speech, language, things like that, to figure out the areas of suspected disability. Or if the district does not suspect a disability, they need to issue a written notice of action to the parent, saying specifically that they do not believe that the child has a suspected disability, and so they're not going to test. And a parent's appeal rights are actually written, should be, so basically that's the parent's notice of appeal, that you can appeal the district's decision through a due process complaint if you believe that the district is incorrect. So if the district and the parent agree to test, the district has 60 days to actually complete the testing. And then the district and the parent come back and review the test results to see if those test results place the child in one of those 12 disability categories. And if they do, then an initial IEP meeting is held within 30 days to determine, okay, how are we going to assist this child and help this child make progress in school. So again, the timeline for the IEP process is 120 days from the day of referral to the day of the initial IEP meeting. And so, that could be a whole school semester. So that is one of the frustrating things about the IEP process, is because there does need to be so much in-depth testing, it can take a long time for the child to actually get the help that they need. But, when that testing is done, the IEP evaluation does not need to be redone for 3 years. And the IEP itself, the document, the team will come back together once a year to reassess where the child is, how are they doing, and do they need additional services or different services to make progress in school. But I will note that you don't have to wait a year to bring the IEP team back together to discuss a change in services if you as a parent feel like your child is not making progress in school and you want to make some changes to what they're receiving. So what's in this IEP document? IEPs can be, 25, 30 pages, and they can be really intimidating, but there's a lot of important information in there. It talks about, what your child's disability category is and how that affects them in school. Goals that the child is going to be working on. So are they going to be working on reading or math or speech or language or, handwriting and occupational therapy? What are the areas of special education that the child's going to be working on? The specific services down to the minute that the child is going to be receiving of special education. So that's how much time are they going to be spending in the resource room with a special education teacher? How much time could a special education teacher be pushing into a regular education classroom to support your child? And if your child needs additional services like speech therapy, language therapy, counseling, that's all included in service minutes as well. There's also a list of accommodations and modifications, such as preferential seating, whether the child needs, additional time to complete assignments, things like that. And then other important things to note, transportation. So if your child has special education services and there are concerns with transportation, and you need that door-to-door transportation, or need the child to be wearing a seatbelt or to have a bus monitor on the bus or things like that, that can be included in the IEP, as well as a behavior intervention plan. so that all staff who work with the child know when a child is having a behavioral situation, what to do to make sure that both the child and school staff are safe. So now some advocacy tips for parents in the IEP process. So first, when you're in an IEP meeting, what I've experienced or seen when, it's a parent on their own, school folks will want to keep it, going as quickly as possible. They may schedule, 30 minutes for this meeting and want to do IEP meetings back to back to back. And some may want to take longer, it really depends on the school. But you as a parent have a right to be part of the team, to ask questions, to make sure you understand why the school is recommending particular services, and to give your input, because you as a parent are a valuable part of that team. So if school folks say your child is making progress, they're improving in a certain area, and say reading, and at home you're thinking, I'm not seeing my child make progress in reading, you can ask, do you have some test scores? Can I see, the data that shows that my child is making progress in school? Because what you see at home may be different from school and vice versa. It's important to be able to understand as a parent, why is the school recommending changes? If the meeting's going too fast, if there's something you don't understand, make sure you ask, because this document you may not revisit this document for a year. So this may be, the services that your child's going to be getting for the next year. So it's really important to understand, what's going on. If you're advocating for additional services for your child, if you feel like your child is not making progress and is not, receiving enough services, make sure you're framing that argument around what will help the child make progress and not around what is best for the child, because the law requires the IEP to help the child make progress, not necessarily for the child to make their maximum progress or do what's best for them. One way to help as you're preparing for an IEP meeting or in general is really to be documenting your interactions with school staff, because I found that classroom teachers can be very honest and very forthcoming in one-on-one conversations about what's going on with your child. And then when you get into the IEP meeting setting, there's a principal, there could be a special education supervisor, there's a lot of folks in the room, and it can be really intimidating for a teacher to speak up and say, here's what I'm seeing. And so if you're not hearing information from the teacher, you as a parent can say, well, I got an email from you saying that, my child has not been completing their work, or that you are having concerns about his reading or his math, or I've gotten 3 phone calls in the last week from the teacher about behavioral incidents. Really making sure that you're documenting that. And so your communication, email and text are very convenient these days, and it's good because that's an automatic paper trail. And it's helpful, not only, for you, but also, a teacher may not be keeping track or may not remember, they had to call you 3 times last week. And so you as a parent can say, hey, I wrote this down in case the teacher is not necessarily aware of the magnitude of the problem until you're sitting down and they go, oh, well, you know what, maybe this is something we need to address because, you are hearing from me a lot. So if you as a parent disagree with the services that the school district is providing or that they're proposing to provide during an IEP meeting, first, if you're concerned about what's going on with your child and you want to discuss changes to the IEP, you can ask for an IEP meeting. Again, do that in writing. And when you're in discussions with the school district or the school about the services the child is receiving, if the school is proposing services that you don't agree with, you can be clear about it and say, I don't agree with what you're proposing, and say why. And if the school is really, really pushing it, you can say, okay, you know what, I am going to let you try what you're proposing, but I would really like to come back in, 6 to 8 weeks to check my child's progress to see how they're doing. And, you can ask, can we put this on the calendar now? So we know to come back in 2 months and say, do we need to make changes? Did this work or not work? If you're not satisfied with what happened at the school level, you can feel free to contact your school district's special education supervisor or special education director to discuss the problem, because supervisors are not always at every IEP meeting and may not always know what's going on at the school level. So it can be something that can be easily resolved by just going up the chain and talking to folks at the district level. And that also kind of helps preserve, I think, that friendly relationship, at least between you and the district, because you're saying, you know, I really want to work this out with the district. And if you're not able to work it out by going to a supervisor, or, you know, they're not being responsive to you, you may consider talking to an advocate or an attorney, or even if you are in contact with, you know, district level folks, bringing in an advocate or an attorney can be helpful, because that IEP process is very intimidating. And it can be helpful to have an additional person with you, you know, to help you understand the process. So formal procedures if a parent disagrees. So in Missouri, desi offers 4 different types of what they call dispute resolution, or ways of solving disagreements between the parent and the district: a facilitated IEP, mediation, a child complaint, or a due process complaint. So a facilitated IEP can be helpful in trying to preserve that, you know, good relationship between the parent and the district. If you request a facilitated IEP, they'll just bring in a a neutral third-party facilitator to run the IEP meeting, and that can be really helpful, just to make sure that both sides are on the same page. So mediation, if there's a specific disagreement around the services your child is receiving, or you believe your child did not get previous services and you want the district to make those up, you can ask for mediation, which is just between the parent and the district. There's no attorneys involved in that. And so a mediator will go between the parent and the district and will try to help the parent find a solution. Will both sides find a solution. A child complaint, any person can file a child complaint, letting desi know that a district has violated the IDEA with respect to a child at any time in the past year. And desi will investigate that and then come back with a determination. And then a due process complaint, which is the most formal type of dispute resolution, and is basically like the special education version of filing in court. You're basically filing a complaint alleging a violation of special education law, and you're asking for a hearing. And so you're basically asking the state to hold a full-blown trial on the issue. And so this is something where you really, really want to talk to an attorney before you file it, because going to hearing, going to trial on your own as a parent can be very difficult, and it's something that you really do want an attorney to be involved in order to make sure that you have the most successful outcome. So a couple notes on special education during school closures. First, we talked about that right to a free, appropriate public education. That is still enforced when school is closed. So the standard for that, if the school is providing distance learning to all students, so if everyone is getting virtual learning, then they must provide those special education services to the extent possible. But if the whole school is closed, no virtual learning for anybody, then they don't have to provide special education service. One thing to make sure of, especially, you know, as we're going into the school year, is that if your child has, you know, has an IEP, that you have access to technology for virtual learning, and the school should be providing that to you at no cost to you, because most distance learning will take place online. And students who qualify for assistive technology devices, those should also be available at home as well. Lastly, IEP meetings virtually. So IEP meetings can still be held virtually. I've had many meetings on Zoom. Schools are still required to hold those IEP meetings and meet IEP timelines if possible. The one thing that may be extended is the actual evaluation timeline if a child is being tested to qualify for special education. A lot of those tests need to be given in person. And so if schools are not having any in-person contact with students, then it can be difficult to do those things online. So those evaluation timelines may be extended, but a district still has to consider initial requests for special education. That's not something that they can put off because schools are virtual right now. Okay, I'll briefly touch on section 504 and then we will go to questions. So section 504 is slightly different from special education and the IDEA, but you do kind of hear about like IEPs and 504 plans kind of lumped in together. So we'll talk about the difference between those. So section 504 is an anti-discrimination statute, and it prohibits discrimination in school based on a child's disability. And the child must have equal access to the same school program as their non-disabled peers. So in order to qualify under section 504, a child must have an impairment that substantially limits a major life activity. So one thing this means is it does not need to impact the child educationally or impact the child's learning in order for the school to have to make accommodations for the child in school. So for example, if you have a child who has a wheelchair and so needs to be able to take the elevator every day, or you have a child with diabetes who needs to be able to have an insulin pump with them all the time, or maybe needs to be able to bring food to class or things like that. A 504 plan can lay out those basic accommodations that a child may need in order to be able to equally access school. So the main difference between an IEP and a section 504 plan is that IEPs provide direct instruction. They provide those special education minutes, those special education services. So if a child needs additional services beyond what the regular classroom teacher is providing, then we're talking about an IEP type situation. Whereas if the child just needs a few accommodations to be able to access the school curriculum, then a 504 plan is appropriate. They can look very similar in practice, especially in the regular classroom setting where the teacher is providing accommodations. And so if you don't qualify for an IEP, consider asking for a 504 plan, especially for mental health diagnoses and things like that. And the other main difference is that IEPs were developed from an educational viewpoint, and Section 504 was developed from more of a disability access law viewpoint, kind of like the ADA. All right, so let's go to questions.
Thanks so much, Maggie, for that great overview. This is a lot of really good information for parents and for advocates, so really appreciate you sharing your knowledge there. And we've had a couple of questions come in. So first, can a school delay the IEP process by putting students on a wait list?
No. We hear that a lot from parents, and the reality in some districts is there is a limited amount of resources, but by the letter of the law, the school has to abide by those special education timelines, those IDEA timelines of 30 days from the date of referral to start the testing, and then 60 days to actually do the testing. So a district should not tell a parent, you're going to be on the wait list and it's going to be 6 months.
That makes sense. So the next question is, if a doctor sends a letter requesting an IEP for a child, does that mean the child automatically qualifies for an IEP?
No. So like I mentioned earlier in the presentation, a medical diagnosis and an educational identification don't always match up. And medical information from a doctor can be really helpful in the special education process, but the doctor cannot prescribe an IEP because those medical diagnoses and those educational identifications are different, but that input from the doctor is very helpful. One other thing to note is that the doctor's information does not count as that parent request for special education. So if the doctor wants to send a letter, it's helpful for the parent to put another letter on top, saying, here are my concerns, I'm requesting special education, and see the attached letter from the doctor. So there does need to be that, additional parent request on top of that.
Yeah, thanks. And speaking of parent involvement, does the school need to take the parents' availability into account when they're scheduling an IEP meeting?
Absolutely. You know, the school needs to do everything, you know, they need to, you know, the school district does need to make attempts to make sure that the parent is able to attend the meeting. So if the school calls and says, it's going to be Tuesday at 3 o'clock, and you as a parent come back, say, well, I have to work, you know, can we schedule it for Friday when I'm off? The school should be accommodating to the parent to make sure that, you know, the parent is able to attend the IEP meeting. Because parent involvement is absolutely necessary to this process. And if a parent has to miss the first meeting for whatever reason, the district is obligated to then schedule a second meeting. And then if the parent does not show up for the second meeting, the district can proceed without the parent. But if the parent misses that first meeting, the district cannot just go on and have the IEP meeting without the parent there.
Great. And what would need to be in a request for testing? Request.
Okay, so yeah, so in a request for testing, you know, generally, I mean, it could be as simple as, you know, I want my child to be tested for special education. It should be directed to the principal and the school counselor. And I think it's generally good to lay out, you know, here are my concerns. So to say, I'm concerned that my son is behind in reading. I'm concerned that he's not completing his work. It can just be very basic. It does not have to be like a formal letter. It can be very short.
Okay. And given sort of the landscape we're dealing with right now, can a school refuse or to hold an IEP meeting if requested to address specific needs for a student with distance learning?
No, they you know, they can't refuse to have a meeting. I mean, if there are concerns with a student, you know, even with distance learning, if the parent requests an IEP meeting, the school is obligated to respond to the parent and make sure that child is making progress. If the school doesn't respond to the parent and the parent is, you know, making contact with, you know, with teachers, especially via email and saying, I'm having these concerns, I want to make these changes to the IEP, can we have a meeting? And the school is not responding, you know, then the next steps would be, you know, does the parent need to be looking at some of those formal complaint and dispute resolution procedures to make sure that they can get the district to the table to make those changes? So that's what the district risks by not coming to the table and talking to the parent, is that the parent has those formal complaint procedures that we talked about before if the district's not responding at all.
Okay. That's really good to know. And when should a parent contact legal services for help with a special education problem?
I think whenever there is a concern that the district is not listening to the parent and is not willing to provide the appropriate services to the child. So if you as a parent have been requesting an IEP for a year and it hasn't happened, and you're being told that your child is on a wait list, or your child already has an IEP and you're concerned that the child needs additional services and the school is refusing to provide those, or says we don't have the resources to provide those and things like that. You know, whenever you as a parent feel like it's not something you can just easily resolve by talking to the school, you know, it's helpful to contact legal services and get our opinion on the issue. And, you know, we don't always necessarily go out and, you know, file complaints and go to court. A lot of times we'll go to meetings with parents and just help parents advocate for the appropriate services for their child while preserving that, you know, parent-school relationship.
We had one more question kind of along the lines of distance learning. If the school does not include the distance learning plan prior to the start of this upcoming 2020 to 2021 school year, are they out of compliance?
And that I'm not sure about, honestly, whether the distance learning plan has to be in there in order to be in compliance with desi regulations. Overall, the federal guidance just requires that the child be provided a FAPE. So it requires that the child be provided their special education and related services to the extent possible. And so if the child is receiving those services virtually, but it's not like written down in a distance learning plan, then it might be just like more of a procedural error. But if the child's not getting anything, or you don't know anything about a plan, then that's definitely an issue because the child's not receiving that free appropriate public education.
Right. And could you talk a little bit more about that desi guidance? Like, what do you do if you're told the school doesn't have to follow the desi guidance?
Well, that would be a great time to talk to an attorney. If the school says they don't have to follow, the state guidance as far as providing services. All public schools and all public charter schools are required to follow the IDEA. So it's different for private schools. But if a public school, or a public charter school is saying that they're not required to abide by, federal guidance and state guidance, and that's a really good time to talk to an attorney or an advocate about, what your options are in terms of moving forward to make sure that your child's able to get appropriate services.
And what about services that can't be provided virtually? This is maybe a school saying that they can't provide certain services in the IEP virtually.
Yeah, and that's a really tough one, and something that was sort of addressed in the spring by some of the federal guidance, where the federal guidance says providing services to the extent possible. So something like physical therapy, they may not be able to provide that virtually, and so then it's a question of safety as to whether or not they're able to work with a child in a one-on-one setting. And so something that I would look to in terms of whether or not, to try to get a school to do something one-on-one is, are they able to do things in person with appropriate social distancing? Are they doing any in-person meetings for any other children? Things like that. But yeah, for things like physical therapy that physically cannot be done remotely, then that is difficult. Because from what I understand from federal guidance, the school districts have to provide it again to the extent possible. And if there really is an impossibility, I think that, there may be some creative ways to get around it, but the school district may ultimately be able to say, we can make that up after school reopens. So one issue I didn't talk about is if something's not able to be provided while a school is remote, then the school should be providing compensatory services after the fact. So if you've missed 3 months of physical therapy because school's been virtual, they should be doubling up on that when school resumes in order to help the child catch up.
This is all really good information to know as we're all navigating this new landscape. So thank you so much, Maggie. And thank you all again for joining us today for the Legal Services of Eastern Missouri's Facebook Live presentation on partnership with MHB and the Missouri Foundation for Health on special education and COVID-19. So just a reminder that a recording of this video will be available on the Facebook page of Legal Services of Eastern Missouri under videos after this live stream ends. Additionally, the slides from today's presentation will be available on our website, so you can check that out and share it. Our next presentation in this Back to School Facebook Live series will be on Thursday, August 20th. That's a week from today at 2 p.m. And that presentation will be on students' rights regarding school discipline in the time of COVID-19. So thank you all again for tuning in.